Hey folks, hey, welcome to today's episode of the Law of Self-Defense. Come on in, everybody, make yourselves comfortable. Sorry, a little bit of a scramble here. Forgot to put my earbuds in. Welcome. Make yourselves comfortable. We're going to be together a while, I think. I have a lengthy press conference to cover today relative to the shooting death of one violent drunk. I'm sure it'll be shocking to hear, violently non-compliant with lawful arrest on a drunk driving charge, physically fought with officers, and ended up getting shot and killed by those officers. Two of them were involved in the arrest. Rayshard Brooks, during the fight with the officers to, try to drunkenly avoid arrest, ended up seizing one of their tasers, tried to use it on the officer during the fight, then fled on foot, pursued by the officers. Rayshard Brooks turned and pointed the taser back at the closest of the two pursuing officers, at which point that officer shot and killed Rayshard Brooks. That's really all the facts you need to know about this case, right there in a nutshell. And the facts have been known forever, since this event occurred back in 2020, so 2 years ago. Despite all these facts being known and being entirely consistent with the lawful use of force by the officers, this was turned into an utter circus for no good reason. By the prosecutor who was in office at the time, who was running a very poor campaign for re-election. He had a lot of skeletons in his closet politically that were emerging. He was looking to lose election. So when this occurred in his district, this occurred in the Atlanta area, he decided to bring charges against these two officers. The prosecutor happens to be black. The officers, of course, were white. The victim here, the violently non-compliant suspect, Rayshard Brooks, was black. So we have all the usual racial dynamics. Atlanta has, of course, a very substantial African-American population. So the prosecutor in office at the time, running for a difficult re-election he was likely to lose, presumably thought, hey, it worked in the George Zimmerman trial. Why not? It works for Attorney Benjamin Crump to make tens of millions of dollars a year in civil settlements. Why not try to raise political capital by racializing this event, by trying to make it seem as if the officers here did something wrong? And the officer who actually fired the shots would be charged with crimes as serious as murder, felony murder, and a variety of other charges. The second officer involved, who did not fire shots, would also face felony level charges. The officer who fired the shots would be fired from his job. And then a year later, the firing would be reversed because, in fact, he'd done nothing wrong. So that was a reasonable conclusion by the Civil Review Board, who to whom he challenged his firing. He was brought back onto the police department. I'd like to think with back pay, but I don't know for sure. And that prosecutor would then go on to lose his race for re-election. The Attorney General of the state of Georgia would ask that a special prosecutor be appointed. One was. That special prosecutor hired a second seat special prosecutor to help him review the case. I want to point out that there was no new substantive evidence developed in this case after the first 24 hours. So all the evidence, all the facts we had to go on to arrive at a legal conclusion here were known within 24 hours of this event. Despite that, there were riots in the immediate area. The Wendy's outside which this event occurred, the location at which Rayshard Brooks had been found asleep in his car, passed out in his car in the drive-through line, was burned to the ground by mostly peaceful protesters. It got so violent in that immediate area that a young girl, 7 or 8 years old, was killed by rounds flying around, fired not by law enforcement, but by mostly peaceful protesters. So the whole event was turned into a complete political and violent and arsonist circus for no good reason at all. Never had to happen. So what I'd like to share with all of you is the news now. Earlier this week, 2 days ago, Tuesday, it was announced that the special prosecutor put on this case had decided to drop all charges against the two officers involved. The only reasonable legal conclusion in this case, but of course, reason does not always govern the legal decisions in these kinds of racially energized cases. And fortunately for the officers, really the entirety of their interaction with Rayshard Brooks was captured both on their body cams and on dash cam from their patrol vehicles, which happened to be pointed in the right direction, not by accident, I would expect. And while the ultimate action, the shooting death of Rayshard Brooks, was not captured on body cam because the body cams had fallen off the officers during Rayshard Brooks' fight with them, and was not captured on the dash camera of the patrol vehicles because they were no longer pointed in the right direction once Rayshard Brooks attempted to flee the area. It was caught on a surveillance camera that was mounted to the Wendy's outside which this event occurred. So we have video of that as well. I know in the press conference they stepped through some of this body camera. There's almost an hour of body camera footage. That's how long these officers were conversing with Rayshard Brooks in a very civil manner. It's only really the last 10 minutes of that interaction that begins to get interesting. I mean, it becomes really clear that Rayshard Brooks is drunk. He's giving inconsistent statements about how much he drank, what he drank. He's asking if he can just park his car and walk home. And of course, the officers are doing what they do in these kinds of stops, and they're gathering evidence of intoxication, if any. They're asking him again, what did you drink? How much did you drink? Do you feel you're safe to drive? Do you feel you had too much to drink? And ultimately, they get Rayshard Brooks to blow into a preliminary breathalyzer device, just a little handheld device that would normally, folks, be followed up by a more supposedly technically more sophisticated breathalyzer device back at the police station. But this is kind of a field device, little handheld device, looks like a yellow cell phone. You blow into the straw and bing, bing, bing. Guess what? Rayshard Brooks was drunk. So they go to arrest him for being unsafe to drive. And that's when the fight ensues. So I'm not sure how much of that video will be shown in this press conference. I have it. Maybe I'll show I have kind of an amalgamation of the different cameras I've all combined. It's about 10 minutes long. Maybe I'll actually show that before we go into the press conference. That might not be a bad idea because the press conference is over an hour, folks. Now, I'm going to try to play it back at a higher than normal speed, see if we can still really understand what they're saying. But I think little bits, and I haven't seen the press conference myself, so I've seen little bits and pieces of it shared by the news media. And it seems to me that the special prosecutors who are hosting this press conference to announce their dropping of charges really do a very good, detailed, evidence-based explanation of why this was lawful. So I thought that would be helpful to everybody. So the very first step before I get into all of that, there is believe it or not, a New York Times article that has, of course, a veneer of propaganda laid over it, but it's not a foot thick. It looks like kind of I don't know, they gave this to an intern to add the propaganda late in the day. So the propaganda is there, but it's relatively minimal for the New York Times. And they otherwise do a pretty good job encapsulating the facts and the surrounding events of this case. So we'll kind of step through that New York Times news report, news in scare quotes, of course. Then I'll share with you, I think, the amalgamated image I have of the various camera angles, the last 10 minutes or so of this confrontation leading up to the shooting. And then we'll step through the press conference and see how productive that is. If the press conference proves unproductive, I'll cut the show short. But as long as it continues to be entertaining, I'll continue going through it and see if I can wrap that up and still have time to get to my jiu-jitsu class this evening. By the way, folks, you may have heard in earlier shows this week, on Monday, I got my ass beat by a 90-pound girl in jiu-jitsu, a purple belt. I believe she was, maybe a blue belt. I don't mean to insult her. I know there's a big difference between the two. Sorry, I just don't recall. Didn't matter. This 2-week white belt didn't stand a chance. And yesterday I got beat by a 290-pound dude, the instructor for the course, a blue belt for sure. It didn't really matter how big they were, folks. Made no difference at all. So there we go. All right, so before I jump in, let me mention, of course, the sponsor of today's show is none other than our very own. Oh, come on, Andrew. Didn't you pull it up in preparation for today's class? Let's see. I know I have it here someplace. Hold on. It will be shared. I had it and I can't believe I didn't keep it. I must have closed that button for some reason, but here it is right now. So the sponsor of today's show is none other than our very own Law of Self-Defense, American Law courses. Folks, these are a series of law school-like courses, first-year law school, semester-like courses taught on a semester basis that we're launching because of the interest we've gotten from the law of self-defense community to provide them with a more comprehensive, in-depth education in these legal topics that, of course, play key roles in the kind of analysis we do in these use of force events and other trials. So we're launching with 4 of the kind of bedrock first-year law school courses: criminal law, criminal procedure, evidence, and constitutional law, with the first of those starting in just a couple of weeks, September 7th, criminal law being taught by attorney Steve Gosney. Steve has been a host on our show many times, including yesterday. He's an extremely experienced criminal attorney from both the prosecution side, the defense side, both the trial level and the appellate level. So we're really honored to have Steve teaching this criminal law class for us starting in a couple of weeks. The other courses on criminal procedure, evidence, constitutional law will follow after that. And this show, these courses are really intended to elevate American citizens to a higher level than they might be if they don't have this kind of in-depth legal education. You know, our lives, our nation, our culture, our society are fundamentally governed by the laws and how they're applied. And if you don't possess that knowledge, your mind isn't really armed. We'd like you to be exceptional American citizens, like the Minutemen during the Revolutionary period were exceptional American citizens. They weren't, well, of course, they soon would be American citizens. Not yet, of course, because there was no America yet, but that was what they were seeking to accomplish. And they weren't just present, they weren't just observers, they were men, as it happens, who had prepared arms and trained themselves to fight the fight. And they were equipped to do that because they knew you needed to be equipped. You needed to be armed to be relevant in that fight. Well, your mind needs to be armed to be relevant in these legal fights, understanding them, fighting them, arguing them. So if you'd like that level, that law school-like level of education, understanding, taught in plain English, it's not legalese, these courses are suitable for anybody, you might take a look at what we have to offer here, and you can do that at lawofselfdefense.com/law courses. Again, the first one starts September 7th, which is 2 weeks from yesterday, folks. So if you're interested, I would encourage you to take a look at that sooner rather than later. That's at lawofselfdefense.com/law courses. And with that, where is my cursor? With that out of the way, just for those of you watching on YouTube, as always, if that subscribe button looks red, you're doing it wrong. Please smash it until it turns gray. Click the bell so you get notifications. Click that like, thumbs up button, and please leave a comment in the chat. Even if it's just your city and state, it helps fool the YouTube algorithm into sharing our content more broadly, which of course is our mission here at Law of Self-Defense, to help make the law of self-defense community, you're already hard to kill. Hopefully you've learned the self-defense stuff, you have a gun, you've taken jujitsu, whatever you feel you need to do so that you're hard to kill. We try to do the second half of that, which is to make you hard to convict. All right, folks. It's going to be kind of a lengthy show, I think. So just a reminder, for those of you who'd like to ask questions and would like those questions to be addressed by me, they do need to be in super chat form, $5 minimum, folks. That's the only way to differentiate. Unless, of course, you're a Law Self-Defense member and you're watching this on the member dashboard. I'm looking now, and it does appear to be working properly. I see the chat going there. If you're a Law Self-Defense member, I would encourage you to put your question in the chat on the Law Self-Defense member dashboard, because we'll prioritize those, and that doesn't cost you anything. If you're not a member, you're just watching this on YouTube, happy to answer your questions, but you do need to put them in super chat form. All right, folks, so let me pull up this New York Times article. Again, it's not like it's propaganda free. The New York Times doesn't know how to do that, but it seemed to me to be a pretty good recitation of the facts of the case, with perhaps a veneer of the New York Times branded TM propaganda. Before I dive into that, actually, let me take a look quickly at the super chats right away, just to see if there's anything I need to cover before we spend the next bit of time. Okay, diving into this. I thought I saw one pop up, but it's not here on my, there is one from E Honda 420. Thank you very much, E Honda. Says, thinking about buying a bike would be my third one. I presume you mean a motorbike. I live in South Denver, want to do a meetup ride sometime. Yeah, I'm happy to do that. I mean, I don't ride locally that much. Most of my trips, except to and from the office, I guess, and to jiu-jitsu, Colorado Springs. Yeah, every once in a while, I do something with one of the local motorcycle clubs, the BMW club or something like that. So, yeah, I'd be happy to. I don't encourage people to ride motorcycles, by the way. They're dangerous. So just 2 cents. I've ridden all my life and would never give it up. But there you go. For me, riding motorcycles is my psychotherapy. Works very well for me. All right, that's super chat out of the way. Let me pull this, where'd it go? This New York Times piece back up. All right, the headline, charges to be dropped against officers in fatal shooting of Rayshard Brooks. Mr. Brooks was shot to death in 2020 after 2 Atlanta officers tried to arrest him. A special prosecutor announced on Tuesday, that would be Tuesday of this week, so the 23rd of August, 2022, more than 2 years after this event occurred. I believe it's more than 2 years. The special prosecutor announced on Tuesday the case against them would be dropped. Again, I'll just point out that the evidence used to arrive at this conclusion, all these facts were known within 24 hours of the event. So if there's no grounds to bring charges today, on August 25th, 2022, there were no grounds to bring charges the day of the event or the week of the event. So Atlanta is the byline. More than 2 years after Rayshard Brooks, a 27-year-old black man, was fatally shot by a white police officer. Again, not that it should matter, the races, right? But of course, that's the world the progressive left has given us. Thanks, folks. Much appreciated. In the parking lot of an Atlanta fast food restaurant, this would have been a Wendy's, incidentally, a prosecutor has determined the officer who fired, as well as another officer on the scene, committed no crimes in the incident. Indeed, as should have been obvious to any reasonable person from the first moment. The article continues, the decision to drop charges against the 2 Atlanta officers was announced in a press conference on Tuesday by Pete Skandalakis. He's the special prosecutor here, a veteran former Georgia prosecutor appointed to handle the case by the Georgia Attorney General, Mr. Skandalakis, and another former prosecutor, Danny Porter. Porter was brought in by Skandalakis as kind of a second seat assistant prosecutor. That's the wrong word. They would have more respect for each other than that, but just the second person to handle the analysis to the extent any analysis is required in this case. But they presided over a multimedia presentation about the June 2020 incident, which showed how Mr. Brooks, after resisting being handcuffed, sparked a violent fight with the officers, during which Brooks took Officer Devin Brosnan's taser and fired it at the officers. So this was a fight that went to the ground. The two white officers were wrestling with Mr. Brooks, attempting to make a lawful arrest of this violently non-compliant suspect. And during the struggle, they had their tasers out to try to use non-deadly means to compel compliance. And one of the officers, Officer Brosnan, managed to lose his taser to Mr. Brooks, the suspect, Mr. Brooks. Mr. Brooks then tried to use a taser against the officers while still on the ground. Brooks got up on, I think it might have been on one knee, pointed the taser, fired the taser. I don't know if it deployed or not, but he clearly points the taser in a firing gesture. That's when Brooks gets up and tries to run away. As he's running away, he turns and points the taser back at pursuing officer, Mr. Officer Rolfe, and it's Officer Rolfe who would end up firing the fatal shots into Mr. Brooks. The prosecutor said that these actions gave the other officer, Garrett Rolfe, justification to use deadly force. Mr. Rolfe fired 3 shots at Mr. Brooks, hitting him twice in the back and buttocks. So if a couple of issues we may as well touch on here. If you're wondering how shooting someone in the back could ever be lawful, well, here's a good example. If someone's fleeing from you, but they reach their arm back over their shoulder to fire a projectile weapon at you, and make no mistake, a taser of this type is a projectile weapon. It fires darts that electrify, and when they work properly, neutralize your ability to defend yourself, to make perform decisive physical acts. And when they work great. Tasers, unfortunately, they often don't work. But of course, if you're the intended victim of a taser, it's only prudent to presume it's going to work. If someone's reaching back over the shoulder, you might engage them lawfully with gunfire, and the rounds might strike them in the back portion of their body. Doesn't mean they weren't a threat. Another common scenario where shooting someone in the back can be lawful is if they have the means to rapidly bring a weapon into play. They may have a weapon in their waistband, but you can see their hands going in that direction from behind, and reasonable to infer that they intend to turn around and use that weapon they're reaching for. Or if a suspect is threatening another person who they may be facing, that other person may not be equipped to defend themselves. You may be acting in defense of others when you shoot that suspect lawfully in the back. So shooting someone in the back does not automatically, by any means, mean that your use of force was unlawful. It depends on, it's always the same algorithm, folks. It's the 5 elements of self-defense. When you shot that person, were they presenting as an unlawful, imminent threat of death or grave bodily harm to an innocent party? If the elements of self-defense are met, your use of force is lawful. By the way, if you'd like to get this, you can. This is our little 5 elements of self-defense law cheat sheet. Lists the 5 elements, provides a brief description of each. We give this away, folks. We don't charge a penny for it. You can get it at lawofselfdefense.com/elements and pick up your own copy. Easy peasy, lemon squeezy. The other question that might come to people's minds, and I don't know if this article addresses it or not, is we commonly treat tasers as if they're non-deadly weapons, less than lethal force. And we do that because that's how they're intended to be used by law enforcement or by lawful defenders. But like most objects, they're capable of being used as either deadly or non-deadly deliverers of force, mechanisms of force. When used properly for lawful purposes, they're appropriately perceived as less than lethal devices. They can kill. Tasers can kill. There is training involved in the proper use of a trainer to minimize the risk that it could kill. Also, they can be used for unlawful purposes. And there's a big difference between disabling somebody for lawful purposes, like you're an officer making a lawful arrest of a non-compliant suspect, because it's reasonable to presume that once you've neutralized their non-compliance, you'll simply arrest them. You're not going to continue to use force upon them. You can't make that presumption if the taser is being used in an unlawful manner to commit a battery, an unlawful battery upon someone, especially if that someone is a police officer who's obviously armed with a firearm. Now they're subject to having the firearm taken by the criminal actor who just tased them. And many, many police officers are ultimately killed. Many of the police officers who are killed with their own weapons taken from them by suspects. And every officer knows this to be the case. Yeah, tasers can kill, even if used with the best of intentions. It's not common, but it's a risk. We actually saw this brought up by the prosecution in the Kim Potter case, arguing that because one of the issues in the Kim Potter case, that was the taser case where Officer Kim Potter shot and killed Dante Wright. She believed she had a taser in her hand. In fact, she had her pistol in her hand. She was charged essentially with reckless homicide, reckless meaning intentionally engaging in conduct you know to create a risk of death and then disregarding that risk and death results. Frankly, the law favored Kim Potter there because she never knew. Even the prosecution never claimed that she believed she had a gun in her hand. Everybody conceded she thought she had a taser. So if she believed she was holding a taser, she could not have been intentionally ignoring the risk of putting a 9mm round into somebody. Tasers don't fire 9mm rounds. But the prosecution actually argued that, well, it should be deemed that she knew she was creating a risk of death, even if she believed she was only holding a taser, because tasers can kill. There are specific methods of use trained for the use of a taser to minimize the risk of death or serious bodily injury to a suspect upon whom a taser is used. So, when the state wants to argue that tasers are non-deadly force, that's what they argue. When they want to argue that tasers are deadly force, that's what they argue. In this particular case involving Rayshard Brooks, the prosecutor in this case argued that, well, sure, Rayshard Brooks pointed a taser at these officers. That's captured on video, was undeniable. But a taser is only non-deadly force. It can't be justification for the use of deadly force by the officers. That's that element of proportionality, folks. Normally, before you're privileged to use deadly defensive force, you have to be facing a deadly force threat. If you're only facing a non-deadly force threat, you're only supposed to use non-deadly force in self-defense. Proportionality, non-deadly to non-deadly, deadly to deadly. So the prosecutor, who was brought charges in this case, who went on to lose election, had his own legal problems. He argued, well, it was only a taser in Brooks' hand. That's only non-deadly force. So therefore, the officers could not have been justified in shooting him using deadly force upon Brooks. That same prosecutor in a recent case in the Atlanta area had charged police who were using tasers on the suspect with using deadly force on those suspects. So when he wanted tasers to be deadly force, they were deadly force. When he didn't want tasers to be deadly force, then he said they were only non-deadly force. Okay. All right, let's continue here. The special prosecutor is quoted here in the New York Times article. It's my conclusion that the use of deadly force was objectively reasonable and that they did not act with criminal intent. One of the special prosecutors said, Officer Rolfe was initially charged with 11 counts, including murder. They charged this cop with murder. And Mr. Brosnan, his fellow officer, faced a number of lesser charges because Brosnan did not fire the fatal shots. The prosecutors said they would move to, meaning the special prosecutors now, the special prosecutor said they would move to vacate those charges. Officer Rolfe was fired from the police department. By the way, the Atlanta police chief lost his job over this case. And those, the police chief is usually pretty politically connected. That's how they get the job in the first place. He lost his job over this case. So Rolfe was also fired from the police department the day after the shooting, but he was reinstated a year or so later by the city's Civil Service Review Board, again, because he had done nothing wrong. Both men, meaning both officers, have been on paid administrative leave pending resolution of their cases. So I guess it's been a long vacation, except for the fact that for one of them, they had a murder charge hanging over their head. You want to be a cop in Atlanta convicted of murdering a black man? That's not a good future. And the other officer was also facing lesser charges, but still felony charges. The article continues. Now that the resolution has come, the rather obvious resolution that the officers acted lawfully in shooting Rayshard Brooks, it seems unlikely to settle a matter that triggered a period of intense protests and institutional instability in Atlanta, a city with a sizable black population that considers itself an unofficial capital of the civil rights movement. I don't know what that's got to do with Brooks or the use of force upon Brooks. And why? Why was this triggered? Why was this chaos, these protests, this arson, this rioting, this looting? Why was this triggered? The officers didn't trigger it. The people defending the officers' conduct didn't trigger it. They didn't call for riots and protests. Somebody did. Who was that? Who stood to benefit by racializing this lawful use of force? It's worth asking. The article continues. Mr. Brooks was killed a few weeks after the murder of George Floyd by a Minneapolis police officer. The Atlanta killing sparked fresh rounds of street demonstrations and became part of broader national debate about the treatment of Black Americans at the hands of the police. By the way, this phrasing that George Floyd was murdered. George Floyd was not murdered in any traditional sense of the word murder, meaning he was killed intentionally, that the officers involved intended him to die. It's a weird quirk of Minnesota law that what would in other states have been called a reckless homicide, they call a lesser degree of murder. But if we think of murder in the traditional sense, as it's taught in law school, that a murder involves an intent to kill, and reckless homicide requires a lesser degree of mental state, an intentional disregard of a risk. One is murder, the intent to kill. The other is a form of manslaughter, an unintended, but nevertheless criminally liable killing. So in no other state, to my knowledge, other than Minnesota, would Floyd's death be technically correctly characterized as a murder. Blah, 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 blah. Then there's a reference here to Stacey Abrams. I'm not going to bother mentioning what she had to say. Donald J. Trump, then the president, also weighed in saying that people should not resist police officers. That's probably pretty good advice. Mr. Trump also said he hoped Mr. Ralph gets a fair shake in the legal system. I would think we'd want that for anybody, right? In the wake of the shooting, the Atlanta police chief at the time, Erica Shields, resigned, and the Wendy's restaurant where the incident occurred was burned down to the ground. Like the Wendy's was responsible for this happening. Well, I guess in some sense. When Rayshard Brooks passed out in the drive-through lane, blocking their ability to do late-night business, they called the cops to get this drunk guy removed so they could get back to work. That's the extent of their liability, in scare quotes, in this incident. The area around the Wendy's was dominated for days by protesters, obviously some of them arsonists, some of whom were armed and threatened passers-by. On July 4th of that year, 2020, an 8-year-old girl was fatally shot while being driven through the area in an SUV. Good work, protesters. Nice job. As Special Prosecutor Porter noted, the police encounter with Mr. Brooks began cordially in the parking lot of a Wendy's restaurant. If you watch the video of all this, folks, the police could not have been more civil and polite with an obviously drunk driver, Rayshard Brooks, throughout the entire conflict, at least up to the moment that Brooks compelled violence because he went into fight mode. Restaurant patrons had complained that Mr. Brooks had fallen asleep, meaning passed out. While behind the wheel of his car in a drive-through lane, the interaction with Mr. Brooks remained businesslike as Officer Rolfe subjected him to a drunk driving breath test, which Mr. Brooks failed. Shocking. But as Officer Rolfe moved to handcuff Mr. Brooks and place him under arrest, Brooks lunged forward, instigating a brawl that left Brosnan with a concussion. Officer Brosnan with a concussion. Brooks stole Brosnan's taser and shot him with it. You think this qualifies as a non-deadly use of force of a taser? When the violent criminal suspect who'd already inflicted a concussion on one of the officers then tases that officer? I'd suggest not. As Brooks ran away, he pointed and fired the taser at Mr. Ralph, who then fired his handgun at Brooks, striking and killing Brooks. Then we have something here from the NAACP. Of course, they're unhappy with the result because they're a political organization advocating racial strife in American society, called upon Atlanta residents. So that suggests to me this guy's not even an Atlanta resident, to push for a new prosecutor. Let's keep getting new prosecutors until we get the legal outcome that we desire, to take the case to a grand jury. And Mr. NAACP said the shooting that shooting Brooks might have been justified just at the point when he was fighting with the officers. But Griggs noted that Brooks was shot while he was running away. He wasn't a threat to anybody at that point. A palpable lie, because he wasn't shot until he turned over his shoulder and pointed the taser at Ralph and fired the taser at Officer Ralph. Video shows that while Mr. Brooks was running from the officers, he turned his body and aimed the taser at Officer Ralph. When Brooks takes the taser, he now becomes basically a person with an offensive position. Prosecutor Skandalakis said he can incapacitate the officers. A taser in the hands of a person who is not trained can also be deadly. Continuing, some observers have noted that at the time Officer Ralph fired his handgun, Brooks had expended the 2 shots that the taser was capable of firing, essentially rendering it ineffective. This is some of the propaganda that we see in these New York Times articles, because they're presenting this as fact. Some observers have noted that at the time Officer Ralph fired his handgun, Brooks had expended the 2 shots in his taser. That's not what the special prosecutor found. At least they don't say that explicitly. And just because people note things, that just means they said something. That doesn't mean it's true. So you'll notice they carefully don't state as objective fact, Brooks had expended the 2 shots. They don't say that. Instead, they have to preface it with this conditional statement to make it sound like it's a statement of fact, when really it's only a statement of opinion, other people's opinions. Contemptible, but of course, par for the course for the New York Times. Special Prosecutor Skandalakis cited a ruling from the 11th Circuit Court of Appeals that says such situations must be judged through the eyes of the officer on the scene. Well, you don't need... That's always the case for a defensive use of force. It's always evaluated from the reasonable perspective of the person using the defensive force, rather than from the comfort of an office or desk where one has the benefit of hindsight and doesn't have the pressure of having to make split-second life and death decisions. Special Prosecutor Skandalakis said it was reasonable to assume that Officer Ralph might not have counted the number of times the taser was fired in the midst of the violent incident that played out in a matter of seconds. Yeah, one of the most common things you'll see in defensive fights, folks, is that the defender can't remember the details of the force that they use. They can't remember how many fists they threw, how many shots they fired. They can't remember the proper sequence of events. We used to see this very often when I was teaching a lot of live courses, law self-defense courses all over the country. I would often bring a very high-end shooting simulator with me, a $20,000 system and a giant Pelican case. And after a full day of law self-defense, we would put the students through this simulator where they'd be shown a video of some kind of threat, and they'd have to solve the problem. And that might involve shooting the person in the video with an infrared pistol, a fake pistol, or pepper spray, or verbal commands, or whatever they decided to do. And then after they had solved the problem of this apparent threat, purely a video threat, folks, no real risk. You can't get hurt by the video projected image, right? After they had solved the problem, they had to turn their back to the screen and tell the class what they saw, what they did, and why they did it. And they couldn't remember what they saw. They couldn't remember what they did. And if you can't remember what you did, you certainly can't remember why you did it. So that's not a poor reflection of law self-defense students. It's how normal people function under stress. The way our brain captures and stores and recalls information under stress is simply completely different than the normal experience. And that would be true of officers involved in a fight as well. Special Prosecutor Skandalakis refuted earlier assertions made by Paul Howard. Paul Howard was the person who was the prosecutor at the time of the event, who was having a difficult time running for re-election, ultimately lost that election, brought these charges in what I think any reasonable person would see as for politically motivated reasons. Mr. Howard had said that Officer Rolfe had kicked Brooks after the shooting, and that the 2 officers had declined to render first aid to Brooks. Special Prosecutor Skandalakis said that the frame-by-frame analysis of video footage showed no evidence of a kicking, and that a number of witnesses saw the officers trying to render medical aid. even though one of those two officers had suffered a concussion at the hand of Brooks. He was still trying to render aid to Brooks. By the way, all this was known at the time. There was never any evidence of a kick. We have the video. The only evidence would have been on the video. There was never any evidence of a kick. So that was a complete fabrication by Howard that he used as the basis for this felony murder charge to show malice on the part of the officers, particularly Officer Ralph. It was all completely fabricated. And yet he caused him to be fired the very next day and then hung a murder charge around his neck. In an interview on Tuesday, I don't know how to pronounce his first name. I don't want to mangle it, but I guess I have to try. Jaimako Brooks, 50, Mr. Brooks' cousin, said he was disheartened by the decision and disputed the idea that a taser should be considered a deadly weapon. Some things just don't make sense, he said. Well, certainly not to people who are poorly informed, who are literally ignorant of the subject matter. I can understand how it wouldn't make sense to an ignorant person. And I don't mean that in a derogatory sense, ignorant. I mean that in a technical sense. They're literally not knowing the subject matter. Amanda Clark Palmer, a lawyer for Officer Brosnan, said in a statement on Tuesday, the decision was long overdue. No kidding. 2 years plus. Despite his own injuries, she said, the lawyer for Officer Brosnan. Brosnan called for and personally rendered aid to Mr. Brooks after the shooting. At no point did he assault or abuse Mr. Brooks. Noah Pines, a lawyer for Officer Rolfe, said that his client was relieved. Yeah, I would be relieved too, to have a murder charge taken from around my neck. Attorney Pines stated, quote, nothing that was said during the press conference today was a surprise to us. Again, all this evidence was known from the first moment. Because we knew the law, and the law justified Garrett Rolfe's actions, and we knew the evidence, and the evidence justified Garrett Rolfe's actions, close quote. Absolutely right. Attorney Pines also accused Prosecutor Howard, the former district attorney, of charging the men for political reasons. Mr. Howard, who could not be reached for comment on Tuesday, was involved in a tight re-election bid at the time in a race that was won by his competitor, now the current Fulton County district attorney. In January, Miss Lewis wrote to Mr. Carr. So Miss Lewis was she was the attorney. Oh no. Miss Willis is the new Fulton County district attorney. She wrote to the state attorney general saying, hey, can you take this political hot potato of a case off my hands? That's me talking, and that's not the New York Times. But the newly elected county DA wrote to the state AG saying, hey, I think my predecessor engaged in misconduct, including using videos of the Brooks shooting in campaign commercials in violation of state bar association rules, and we need a special prosecutor to handle this case. Again, I think it was mostly she just didn't want to take this hot potato. The new prosecutor, asked the state attorney general to refer the case to a special prosecutor. He initially declined, but the courts eventually sided with the new prosecutor, county prosecutor, prompting the state AG to choose special prosecutor Skandalakis, a former prosecutor for a stretch of West Georgia, who currently serves as the executive director of the Prosecuting Attorneys Council of Georgia. Okay, that's all fine. Let's see. At the news conference, it was noted, a reporter noted that both special prosecutors were white men, and another reporter asked if race played any role in the shooting. The prosecutor, Skandalakis, said, I don't change the facts based on the color of a person's skin. I do not think the shooting was racially motivated. Fair enough. Okay. And that is the New York Times article. So let me open the window up a bit more. I'll take a new look to see if new super chats have come in. And let's see. Arthur Peterson, $5 super chat. Thank you very much. Arthur writes, admit it, Andrew, you're just a shill for George Soros. Okay. I will take that in the humorous fashion in which I know it was intended. Arthur Peterson, again, another $5. My first super chat was a joke, but I do respond. Since Brooks had deployed the taser and it missed, there's no more imminent threat to the officers. Well, most of the modern tasers can be used in both projectile mode and a stun mode. So For example, there's models that have 2 sets of projectiles. So you get 2 shots out of it. I believe that's the form of taser that was being used here. Even if both shots are expended, you can still use the taser in stun mode to at least partially disable the intended target. So no, the taser is still a threat to the officer. And that presumes, of course, that the officer would know with certainty, and it would have to be certainty. He's not required to incur a risk of death by just assuming 2 shots have been fired. He'd have to know for certain that both shots have been expended to know that the taser no longer had a projectile capacity, and that's not realistic. He never claimed that he knew that, and it would be unrealistic to expect that. Zenothium 15, $5 super chat, thank you very much, writes, didn't the Attorney General of Georgia come out either a few days after or before say that under Georgia law, tasers are considered a deadly weapon? I don't know if he said that or not. They wouldn't be considered a deadly weapon by default because they have non-deadly application. So some weapons are considered deadly as a matter of law because in their normal use, there's no way to use them really without substantial risk of death or serious bodily harm. So if you were using shooting someone with a gun, that's always going to be deadly force. Doesn't matter if you shoot them in the foot, a gun is deadly force. Substantial risk of death or serious bodily injury, which is the definition of deadly force. If you're using a knife in an aggressive manner to stab somebody, that's always going to be deadly force. Impact weapons, however, and things like tasers can have either deadly or non-deadly application depending on the manner of their use. With respect to, say, a baton, a police baton, most officers these days are trained to use a baton in a non-deadly fashion, meaning strikes to the large muscle groups of the body, normally the upper legs, to compel compliance with lawful commands. That would be a non-deadly use of a baton. But if you strike someone in the head with a baton, that is a deadly use of the baton. Same baton, same force of swing, but the difference in target, the difference in application changes it from a non-deadly application of force when used against the upper leg to a deadly application of force when used to strike someone in the head. Taser can make the same argument. When it's being used in its lawful and proper way to compel compliance of a non-complying suspect, you're going to use it until they're no longer non-compliant and cuff them up and the use of force is over. If even a police officer was using a taser to torture a confession out of somebody, then the harm being caused, the pain being caused is unjustified and might well be characterized as serious bodily injury. It's not transient, it's being used repetitively, and then it could be a use of deadly force. Again, deadly force doesn't require that the force can kill. It requires that the force can either kill or cause serious bodily injury, and a sufficient degree of repetitive pain would qualify as serious bodily injury. So it all depends on the manner of use. And by the way, when it's being used for unlawful purposes, that heavily shifts the scale in the direction of what could have been a non-deadly implement intended for non-deadly uses when lawfully and properly used. When it's being used for unlawful purposes and or improperly, that heavily shifts the scale toward being interpreted, that application being interpreted as being a deadly force use. All right. Now I think I'm going to see if I can, I'm not sure if I can do this, if I can pull up this compilation video. Let me see if I can make this work. Here is the video. Let me see if StreamYard will let me share this. You know, I think I can do it if I blow it up to cover the whole window. All right, I think I can. So this is about 10 minutes of video, folks. So I'm going to play it through. It's the last 10 minutes of the interaction between Rayshard Brooks and the 2 officers, Ralph and Brosnan. These are their body cameras here at the top. So the body camera of Officer Brosnan, who is standing to the left of Officer Ralph. That's Officer Ralph we see there in the upper left frame. Officer Ralph is on the right of that upper left frame. He's being captured on the camera being worn by the other officer on the chest of Officer Brosnan. On the upper right, we have the body camera that's on the chest of Officer Ralph, and he's capturing Officer Brosnan there in the upper left of that frame. And of course, centered in both is the suspect here, Rayshard Brooks. And this has been going on, this conversation, for half an hour. So I believe it was Brosnan who first came on the scene, and Brooks was in his car in the drive-through lane, passed out. And Brosnan shook him awake, and he said, buddy, you can't stay here. You got to move your car. Agreed to let Brooks move his car. It's that white car in the background there behind Brooks. Move it to that parking spot so it would be out of the way. But Brosnan actually shook Brooks awake, asked him, conversed with him, told him he had to move his car. Brooks agreed and immediately passed out again. I mean, that's how drunk Brooks was. Then he had to wake him up again. He finally moved his car. Brooks is out of the car, and the second officer, Rolf, shows up. And Rolf is, I presume, is the more senior of the two because he's leading the rest of the conversation, the interview, the interaction with suspect Brooks. And I can only tell you the first 30 minutes is, I don't include it here because it's just so redundant and repetitive. It's just a really drunk Rayshard Brooks. And you'll see that too here in this last 10 minutes. So Brooks is giving inconsistent statements. How much did you drink? 1, 2, 1.5. What were you drinking? Daiquiris, margaritas, he says later. You sure you weren't drinking daiquiris? Oh, definitely no, I was not drinking daiquiris. They were margaritas, even though earlier he'd been insisting he was drinking daiquiris and not margaritas. So he's obviously confused. He's obviously drunk. He himself tells the officers, listen, I already told you I was drinking. You know I'm drunk. And then, of course, he does the breathalyzer and blows positive on the breathalyzer. But you don't need to be a rocket science here to see that Brooks is intoxicated and effectively confesses to driving under the influence while he's talking to the police officers. So I'll play this through, and I just the reason it is 10 minutes is I wanted you to see how civil and polite these officers are with Brooks. This is not a couple of these hypothetical racist Atlanta police, as if you could survive on the Atlanta Police Department. Atlanta's what, 50% African American? You think they have a lot of obvious racists on their police department? How would you survive in that job? But in any case, you'll see there's nothing like that here. So it's about 10 minutes, and it's just to give you a sense of how polite these cops are. Maybe other things will come to mind as it continues. Now, in the last few moments of this, I have a couple of additional frames that will pop up on the screen. They begin when the fight goes to the ground, when Brooks begins to violently resist arrest. On the lower left, we'll have the video from the dash camera of one of the officers' police cars, so you can observe that fight, because the officers lose their body cameras right away in the fight. So we don't get any more useful footage from the body cameras after the fight begins, but we can see the fight from the dash camera footage. And then ultimately, Brooks, of course, attempts to flee. He runs across the parking lot, so he runs out of frame of the dash camera in the patrol car, but he runs into frame of a security camera mounted on the outside of the Wendy's before it was burned to the ground by quote-unquote protesters. And those are the frames from the Wendy's security camera in which we could see Brooks fleeing from left to right, being pursued by Rolf and then by Brosnan, and Brooks reaching over his shoulder, pointing the taser at Rolf, and Rolf shooting 3 times, striking Brooks twice, mortally wounding Brooks. And that's the end of the video. All right, let's go ahead and play this and see how this works. Hopefully the audio will come through. Tell me in the comments if the audio is coming through. If it's not, then there's no point in playing this. Or at least I might advance it up to the point of the fight. Here we go. No audio. Okay. Let me see if I can fix that. Maybe there's a setting I have to hit. Okay. Because I can hear it on my end. But it will save you all 10 minutes of time if it doesn't work. Let's see. Okay, this might work. Let me see if I can get this to work. Share audio. Try one more time.
So, but no margaritas at all today.
No, it's just a daiquiri.
Just a daiquiri.
Yes.
All right.
And Natalie White.
Right. And you haven't drove your vehicle at all.
You say you caught me in the
right there. I woke you up and then I said you can move.
Cool. Good audio.
And you said okay, and then you went back to sleep. Then I opened your door again. I had to shake you, and you woke up, and then I asked you to move the car over there.
That's the BP by the Marathon Jonesboro Road. This is University Avenue.
Yes. Very good.
This is University Avenue.
Yep.
I growed up here.
Okay.
You know, Natalie White, she's my girlfriend.
Okay.
She left off. I said, babe, I'm going to get Wendy's and I'm going to go back to where.
That's what I asked you was, have you drove that vehicle?
I mean, probably from the point of the drive-through to here to park.
Okay. And how did it get into the drive-through?
She pulled out. I pulled out from here where this red car was. I remember this red car pulling out.
So it got into the drive-through.
It's like talking to every drunk person in the world who's trying to get out of trouble.
I mean, if you caught me in the drive-through, then I didn't drive here.
My question is, your vehicle got into the drive-through because you drove it
backed
there, right?
out and drove, you know, said, baby, I need burgers. She said, okay, fine. I'm going home.
My
said,
question,
no problem.
Just so I understand what happened clearly.
That's as big as I think I can make it, folks. Sorry about that.
Your girlfriend dropped you off. You got into your vehicle. You backed it out.
I think. Let me see.
Pulled it into the drive-through, correct?
Yes, sir.
And
Yes, sir, Mr. Ross.
And then what led to you falling asleep behind the wheel?
I was on the phone calling her. She didn't answer. I said, babe, last time I answered. I said, baby, I'm getting burgers and, you know, what's going on? She said, you supposed to get burgers. Just go ahead and get burgers. And the phone went dead.
Okay.
I said, well,
I'll just take a nap
you
then.
don't know your order, you know, whatever the case may be, just let me know. And the phone went dead. Like I said, I can call her now. Natalie White. She stays right down the road. I have a parking spot right down the street here.
Okay.
Like I said, if I call
For those of you who are patrol officers, God bless you.
The question that I asked you?
Yes.
What did I ask you?
You said, how did my car get from the driving spot to the drive?
Right. Well, that was the previous question. We answered that question. My next question was, what led to you falling asleep behind the wheel? Why did you fall asleep behind the wheel?
I fell asleep because I can't blame nothing on her. It was my decision. I said, hey, if she can't get her order together, and you know I'm not feeling uptight right now, I should park right here. Go to sleep. I'm not feeling
because he wasn't asleep right there.
Right.
He was asleep in the drive-through.
She,
Do you think maybe that you had too much to drink and you realized that you shouldn't drive, so you parked?
I mean,
would that be accurate to say?
Now poor Brooks is like, do I say yes or no to that?
All right, so your girlfriend dropped you off, you got into the car.
I mean, that's a confession that he was operating the vehicle
like,
intoxicated.
And so you pull back into the parking spot and park, right?
I call her and like, babe.
Is that accurate?
It's a couple moments I got on the phone with her.
Look at this terrible police abuse,
I'm like,
folks.
babe, hey, damn,
Look at how brutal this
you want
is.
number 1 or number 2 or?
But
she's like,
would you agree?
You take care of that. You're a man. You figure out what we're going to eat tonight.
All right, let's move past that. Would you agree that you've had too much to drink to drive?
I mean, I can focus, Mr. Ross. I can focus.
Would you agree that you've had too much to drink to drive?
I haven't had, to the point where I can't focus.
Okay.
I was a little tired ahead of the day because we just came from North Carolina.
Do you think that you're safe to operate a vehicle right
Absolutely, Mr. Ross.
now? And how much have you had to drink?
I had 1.5 margaritas, Mr. Ross.
1.5 margaritas.
Yes, sir.
Margaritas.
Yes.
Have you had anything else today? Any other type of drink?
No, sir.
You haven't had any daiquiris?
I haven't had no daiquiri. I had.
Rolf is mentioning daiquiris because earlier Brooks had insisted he'd had daiquiris, not margaritas.
Y'all got me up with this.
Got you up.
I'm going now.
I got you. Hey, will you take a preliminary breath test for me?
What's that?
It's a little handheld machine. I have you blow into it, and that lets me know if you're positive or negative for the presence of alcohol in your breath.
I've been drinking. I do say that.
Okay.
But I'm only going a few minutes down the road.
I got you. I'm just asking, will you take a preliminary breath test for me?
I mean, I don't know what it is.
I just said it's a little handheld machine. Lets me know if it's positive or negative for the presence of alcohol. That's part of my investigation.
You know it is the presence.
I know.
Drinking.
I know. I can tell. That's just part of my investigation.
But
it's
like I said, if I have to park this car right here, right now,
hold on. It's just a yes or no. We don't need to go back and forth about it. It's just a yes or no.
But what if I take this test and I don't care about? I can walk home.
Well, maybe not.
I don't have to park. The car's legit.
Why would you walk home?
I just don't want to be in violation of anybody. I can walk. My sister's house is right here.
Do you think that you'd be in violation of something if you were to drive your vehicle?
If that's less possible for me to park here, lock the car up, and do everything that I need to do within the presence of you guys, I can just go home. I have my daughters there right now. My daughter's birthday was yesterday.
All right.
That's a good reason to get out of a DWI, I guess. My daughter's birthday was yesterday.
I don't want to refuse anything.
It's yes or no. It's completely up to you.
Yes, I will.
Okay, just wait here while I grab it.
It's completely up to you. Folks, especially if you're drunk, you don't want to blow in that tube. That's not going to be helpful at all. I mean, what are you going to do? Inhale? First of all, you can't. It won't let you do that. So here's a little breathalyzer.
All right, just take a deep breath in.
These can be fun at parties, by the way.
As hard as you can, tell you to stop. Blah, 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 blah. Stop. Very good.
I just had a few drinks. That's it.
How many?
Right. The little screen on the device says a ton of drinks.
I told her, babe, let's go because I'm hungry.
What kind of drinks did you have?
I'm not sure. It's something she ordered. She said top shelf or whatever.
Top shelf what?
I'm not sure. It was, like I said, it was her birthday and it was my daughter's birthday intent to, have a good time. And I said, babe, I'm hungry. Let's go. My baby's mom, she was there. I said, babe, go ahead. I'm cool. Here's the money.
All right, so now they have the preliminary breathalyzer. He's obviously drunk. They're not there to just let drunk drivers just walk away. That's not. There's actually punishment for drunk driving. So they've already made the decision.
You had about 1.5 drinks, but you don't remember what kind of drinks they were?
No, sir.
All right.
I really don't, Mr. Ross.
All right. I think you've had too much to drink to be driving. So put your hands behind your back for me. Here, put your hands behind your back.
There's the fight. There's a dash camera now in the bottom left.
Hey, stop fighting. You're going to get tased. You're going to get tased. Stop. You're going to get tased.
There, Brosnan was using the taser in stun mode. Now Brooks is fighting for control of Brosnan's taser. Brooks will come up with the taser, point it. See, now Brooks has the taser. He's got the effing taser. Oh, points it as if to shoot it. Maybe does shoot it. The pursuit in the bottom right now. Brooks points the taser back. 3 shots from Ralph, and that's the end of that event. And that's that. So that's the entirety of the event. I mean, really, the action only takes a minute or so. But I wanted to share the preceding 9 minutes so you could see how polite and civil those officers were. I mean, there was no racism in that encounter by any stretch of the imagination. And frankly, if Brooks had simply run, he almost certainly, I mean, they had his car. They would have found him, but they pursued. They could have tackled him. I mean, there was no reason he had to die except for the fact that he turned and pointed the taser back at the officers. And then they have a reasonable perception they're facing an imminent deadly force threat, meaning a threat of death or serious bodily injury. And deadly defensive force becomes completely appropriate under those circumstances. And again, all of these facts, all of this video was in the possession of the authorities within moments of this event. This is not new information. This is information they had, including then District Attorney Paul Howard, had from the get-go. And there's only one interpretation of this evidence, consistent with the law of Georgia and every other state, and that is that this was a lawful use of deadly defensive force. So instead of getting a DWI conviction, or maybe not, if you got a good lawyer, who knows, but instead of getting a DWI conviction, Brooks got himself dead for no particularly good reason. Sorry that happened, but that's the way it is. All right, let me take a look back at the comments now. I skipped the membership comments before. Sorry about that, folks. So I'll start there now. Richard, a law self-defense member, writes, I saw some statistics where if you removed something like 8 of the worst blue crime cities in the USA, we have nearly the lowest murder rate of all nations. Yeah, I mean, if you take out the top 10 most violent urban centers in America, we have the gun crime rate of Switzerland. So it's not a gun problem, folks, and it's not a homogenous problem spread throughout the general population. There are particular bad actors. And if we were willing to take those identified, known bad actors and lock them up for long periods of time, we wouldn't have much gun violence. Violence committed with guns. Of course, there's no such thing as gun violence, literally. Guns don't self-animate and commit acts of violence. Donnie, law self-defense member, very well informed. Law self-defense member, writes, common law murder included reckless homicide. Malice aforethought was implied by the law on the basis of reckless conduct that was inherently dangerous. Yes, there's a lot of that old common law stuff that is the foundations, the underpinnings of American law, but modern American law has taken things further with differentiating various mens rea, various mental states for crimes in America. Let's see. Rick writes, law self-defense member, I think the bottom line is comply with the police. You can beat the rap, maybe, but you can't beat the ride. Not if it's moving at 1,000 feet per second. You can't. Let's see. Joe, law self-defense member, writes, I had 2 drinks, officer. The standard quantity of every drunk driver since the Hittites invented mead and the chariot. Yeah, that sounds about right. Okay, that's all the law self-defense member comments up to this point. And what we're going to do next, folks, is jump into the press conference. Arthur Peterson, again, another $5. Thank you. He writes, this $5 is literally just a thank you for answering my previous ones. You're awesome, Mr. Branca. Thank you very much, Arthur. Brandon, let's go. $5 super chat. Thank you very much. Writes, tie off. It's almost 5 p.m. Eastern time. Well, for one thing, I'm not in Eastern time. I'm in Mountain time, where it's now 3:09. So a bit past 5 on the East Coast, but no tie off. And I'm hoping to get today's work schedule wrapped up in time to get to jiu-jitsu down in Colorado Springs. So definitely no tie off, and definitely no drinking. Brian Schultz, $5 super chat. Thank you very much. Says, was Brooks a third strike felony offense may have influenced his unwillingness to be arrested? Maybe. I don't know. So, in theory, in a jurisdiction that has 3 strikes and, these kind of sentencing things are not my particular area of expertise. So I don't know off the top of my head if Georgia does that, the 3 strikes model. But normally once you get 3 strikes, it can be a very, very, very lengthy prison sentence, often life in prison, regardless of what that third felony would normally have called for in sentencing. But whatever sentence he might have been looking at, first of all, he would have had a legal defense in court. So he might have won. Who knows, or at least got a plea bargain, a favorable plea bargain, if he hadn't threatened a police officer with deadly force and got himself killed as a result. So there's no sentence that would have been less favorable for him than death. Death is as least favorable as it gets. All right, so let me see now if I can pull up this press conference. I believe I can. I'm going to start playing it, and I'll see if I can play it at a little faster than normal speed and see if it still sounds reasonable for everybody. So we're starting here with Special Prosecutor. Good heavens. Somewhat complicated name. Skandalakis. So this is Special Prosecutor Skandalakis, the bald-headed gentleman. His colleague, Mr. Attorney Conrad, would also make some comments later on, and they'll project on a screen in this room some of the video we've already seen. It's not very clear because it's being projected on a screen and then transmitted over the internet, but we've already seen the video, so it shouldn't really matter. But let's go ahead and hear what Special Prosecutor Skandalakis has to say.
Go back and pick up policies that we wanted to look at, and they were able to do that as well. So thanks to the Atlanta Police Department. I also want to thank Attorney General Carr for having faith in me and appointing the case to me in my office and allowing us to do our job as we saw fit and to do what is right. I also want to express my thanks to Mr. Danny Porter. When I first got the case, Danny Porter, you may or may not know, is a former district attorney for Gwinnett County. He served as the elected district attorney for 28 years. Prior to that, he was another, I think, 11 or 12 years in the office. He brings 41 years of experience to the plate here, and the information he brought was invaluable, and he is co-counsel with me on this case. And I want to go over with you just how we're going to handle this. We do have a PowerPoint presentation that we will be presenting. I'll be going through part of it, and then we're going to do a video analysis. That will be Mr. Porter's part. He will go through the video with you step by step, and we'll go over what the evidence is. And once we do that, we'll have concluding remarks, and we'll open up the ground for some questions. If you have any questions, we'll be glad to answer those questions. The way the order will proceed is I'm going to talk a little bit about the experience of my team. I'm going to talk about the background, that is how the case got to us. I'm going to talk about the facts of the case, then we'll go to the video analysis, and then we'll go to the conclusion. So again, like I said, at the end of this, we'll open up.
The volume is what it is, folks. Maybe crank up the volume on your end.
And victim advocate in my office, we have combined with my 37 years of experience, we brought to the table about 137 years of prosecutorial experience in the field of criminal law. Then, like I said, I contracted with Mr. Porter and brought his experience to bear as well. We also decided that after we looked at this case, that it was in need of expert analysis. So we went out and we hired experts to review everything from the audio tape, the videotape, the investigative files, the APD policies. Also, we wanted to see human reaction time and how a human responds to certain events of stress. And we had those experts break down the video in a frame-by-frame analysis, which had not been done prior to us handling the case. It had not been done prior to that time. Mike Alvin was our expert on video analysis. We hired Force Science, or Dr. Walensky and Von Klein for our expert analysis. And we requested that they put their findings in writing, and those will be available to you, not at the the end of the day, but we will make those available to you.
So Force Science Institute, for those who don't know, it's an institute that studies the use of force, human dynamics. I'm a graduate of their week-long course. So there you go.
At some time. Background of this case, and I think the background of this case is important. And I think it's important because we have to remember what mood our country was in 2020 when this happened. We have to remember what mood our state was in. And so I'm going to go back all the way to May 29th when peaceful protests started.
Good suggestion on the closed caption.
The Ahmaud Arbery case and the Breonna Taylor case. And during those peaceful protests, as you know, they basically were in Atlanta, around the CNN building, around Centennial Park. And after a while, some of those peaceful protests became violent. There was destruction of buildings, destruction of property. And eventually, the mayor, on the next day, May 30th, had to declare a curfew. And that curfew lasted from May 30th until June 4th. And why is that important? I think it's important so you understand and the public understands under what atmosphere all this was happening. Now, I will say this, that this case of Devin Brosman and of Garrett Rolfe is not like the George Floyd case. This is not a case in which an officer was dealing on a prone suspect for 9 minutes. It's nothing like that. Nor is it like the Ahmaud Arbery case, where armed citizens were chasing a person down through a neighborhood. This case, its facts are different. Its facts are distinct to this case, but you can't ignore the fact that all of this was happening at the same time. On June 9th, just a few days later, about a week later, incumbent Paul Howard finished second in the primary to Fonnie Willis, who was the challenger for district attorney of what is the Atlanta Judicial Circuit, but many of us refer to it as the Fulton County District Attorney's Office. On June 12th is when Officers Brosnan and Officer Garrett Rolfe encountered Mr. Rayshard Brooks at the Wendy's on University Avenue in Atlanta, Georgia. And that's the day that this incident occurred. Just 5 days later, Fulton County District Attorney's investigator took out multiple warrants against Garrett Rolfe and against Devin Brosman. I will say that at that point, the GBI had not completed its investigation. In fact, it would be 130 more days before a complete investigation was turned over to the Fulton County District Attorney's Office. And as y'all know, on on August 11th, Paul Howard lost the race, the election of Ms. Fonnie Willis. And then on January 25th of 2021, Fonnie Willis wrote a letter accusing her office from taking on this case based upon the conduct of her predecessor. On February 9th, Attorney General Chris Carr rejected that request to recuse her office. Ms. Willis asked him to reconsider, and he denied that reconsideration. The case then went on until April 6th, when a Fulton County Superior Court judge ordered D.A. Willis to show cause why she could not handle the case. On June 4th, after our hearing, the Superior Court judge in Fulton County recused Fonnie Willis from the case. And then on July 21st, Attorney General Carr appoints me, Pete Scandalakis, as the lead prosecutor in this case. After that point, we began to get our team together. We began requesting information in the case file. We began contacting Mr. Porter to see if we could contract with him. We'll also look in the investigative file. We also contacted Ms. Tamika Miller. Ms. Tamika Miller is the widow of Rayshard Brooks. We made contact with her and brought her into the office and let her know that we had been appointed to the case, that we had not received the full case file yet, but that we would keep her apprised of everything that was happening. And when I say everything that was happening, from the time we received the case file to the time we hired the experts, to the time we received the experts' reports, we kept Ms. Miller advised of the situation and have even advised her today. I also want to point out in preparation of this case, and I think it's important to understand, that before this press conference was called, we made contact with APD to let them know there would be a statement made today at 1:30. We contacted the Georgia Bureau of Investigation. We also contacted Morrow Police Department, and we contacted the governor's office as well as the Attorney General's office. And I'm sure I'm forgetting the Sheriff's Department, and I also spoke to Ms. Willis last night. So we have contacted all those people in preparation of this press conference. Now I'm going to go into a little bit of the facts on this case before I turn over the video analysis to Mr. Porter. On June 12, 2020, Mr. Rayshard Brooks was at the Wendy's on University Avenue in Atlanta, Georgia. And what had happened is before 911 was even called that day, the employees were receiving complaints that there was a man passed out behind the wheel of his vehicle in the drive-through lane. Now, if you remember back around that time when we were having COVID and all that, The drive-through was the only way you could get to the Wendy's. The dine-in was closed at that time. So the employees were receiving complaints that someone was blocking the drive-through. Eventually, the manager of Wendy's went out and knocked on the window of Mr. Rayshard Brooks, trying to wake him up. She knocked on the window, kept knocking on the window, was unable to wake him up. Finally, he woke up, he rolled down his window, and the manager asked him, "Would you please move your vehicle?" According to the statement made by the manager, the only thing Mr. Brooks did was stare at her, roll the window back up, and he fell back asleep. One Wendy's employee reports to the GBI, made a statement to the GBI that prior to calling 911, Mr. Brooks had been at that Wendy's, parked in that drive-through lane for about 40 minutes. Finally, a call was made to 911, and Officer Brosnan was the first officer to respond. And you will see part of this videotape when Mr. Porter plays the video analysis. Now, let me point out the videotapes that we have and the whole timeline of how long Mr. Brooks was in an encounter with the Atlanta police officers is 40 minutes and 23 seconds. Obviously, we're not going to play that entire video, all the body cam videos and the Wendy's video for you today. But the entire time is 40 minutes and 23 seconds. During that 40 minutes and 23 seconds, there is conversation between Mr. Brooks and the police officer. Much of it, if not all of it, is cordial. It doesn't become cordial. It switches from cordial to violent when the officers seek to place him under arrest for driving under the influence, and Mr. Brooks lunges at both officers and basically overpowers the officers. And you'll see that. Manages to take the taser away from one officer, tries to tase that officer 2 times, tries to tase the other officer another time, manages to take off running and was pursued by Mr. Rolfe. He fires the taser back at Mr. Rolfe, and Officer Rolfe fires his weapon. And Mr. Porter will go into that in detail. But prior to that, Devin Brosnan shows up, knocks on the window, cannot awaken Mr. Brooks. He finally opens the door to the vehicle and again tries to wake Mr. Brooks, finally gets Mr. Brooks to wake up and says, "Hey, you're blocking the drive-through. You need to move your car. Please move your car." And Mr. Brooks looks at him, says, "Okay." They shut the door. Brosnan begins walking back to his vehicle. Before Brosnan can get back to his vehicle, Mr. Brooks passes out again. Brosnan immediately turns back around, goes over, again, knocks on the window, opens the door and says, "Hey, please move your vehicle. You got to move your vehicle." In one of those conversations, Brosnan even asked Brooks, he says, "Do you need medical attention? Do you need medical help?" Brooks says, "No, I'm fine." He says, "Well, you got to move your car." So he watches as Brooks moves his car out of the drive-through. And when Brooks moves his car out of the drive-through, what happens is Brooks drives over the curb onto the grass in a parking space. He then backs up into the parking space. Brosnan walks up to the car and asks Brooks for identification, goes back to his car, notices at that time the smell of alcohol. So he calls in for a DUI officer. That DUI officer, recognized as an expert in the DUI field, that DUI officer is Garrett Rolfe. About 10, 15 minutes later, Garrett Rolfe arrives and asks a few questions of Officer Brosnan and says, "What's going on here?" Officer Brosnan explains to him the guy's asleep and behind the wheel of his car, asked him to move his car. He drove over this curb. After he drove over this curb, I went to get his license. I noticed the smell of alcohol. Brosnan says, Garrett Rolfe says, "Okay." Then Garrett Rolfe goes over and starts talking to Brooks. And as he's talking, he's asking him, "Where are you? Where have you been?" Brooks tells Brosnan that he's in Forest Park. Brooks tells Rolfe that he's in Clayton County and that he's at a hotel. He's staying at a hotel just down the road. Well, he's not in Clayton County. He's not in Forest Park. He's in Atlanta, Georgia. They notice glassy eye, a little bit of slurred speech. They do field sobriety tests. I say they. Officer Rolfe does field sobriety test, and then asks Brooks if he'll take a breathalyzer test. And he says, "Yes, I'll take the breath test, the portable breath test." He takes the portable breath test, and again, let me point out now, we're over about 39 minutes into this whole situation. The conversation's been cordial. Mr. Brooks has been very cooperative. The officers have been professional. Everything's going as planned. He takes the portable field test. It comes back 0.108. And as y'all know, over 0.08 in Georgia's over the legal limit, and you're presumed to be under the influence at that point. It comes back 0.08. Officer Ross tells him, "I think you've had too much to drink to be able to drive." And Officer Ross goes to place handcuffs on Mr. Brooks. And Officer Brosnan goes to get the other hand. When he does that, Brooks lunges forward and manages to get out of being handcuffed. He then is able to get Brosnan basically on his back. As he gets Brosnan on his back, he is getting control of Rosalind's taser. He grabs control of the taser. He finally gets control of the taser. And you'll also see in the video, and Mr. Ford will point this out, and at one time he strikes Officer Rolfe across the back of the neck, across the neck in the face. He gets the taser from Brosnan, and he tries to dry stun. He puts the taser against Brosnan's neck and tries to dry stun him. He then takes the taser, he aims it at Officer Rolfe and fires at Officer Rolfe. He also then, Brosnan now is on his knees. It's important to note that when all of them went down on their knees, Brosnan was on the bottom. Brosnan's head struck the concrete, the pavement of the Wendy's parking lot. He suffered a concussion, and he was a little bit out of it, but he managed to get to his knees. As Brosnan gets to his knees, Brooks holds the taser over him and fires almost point blank into his head. We know that the charge hits Brosnan in the hand, and Brosnan tells the police, the GBI, that he felt the current going through his body. Again, Rolfe is trying to tase Brooks, but what happens, again, Mr. Ford will go through this with you, is the taser leads do not connect to make a good current. So one of them gets stuck in his clothing. Witnesses are reporting or videotaping this too, and Mr. Ford will go into that. Brosnan's on the ground. Rolfe is a little bit of a distance. Brooks takes off running. Brosnan, again, is out of it. He's on the ground, and Rolfe takes off after him. As Rolfe is chasing him, you can see Brooks turn and fire the taser more than once. I think it was 3 times he fires the taser at Officer Rolfe. During one of the times when Brooks is turning and firing, that is when Rolfe switches from his taser, starts to pull out his weapon, fires 3 shots within 0.56 seconds. The report will go all over that. Those are the facts of the case in a synopsis. I will tell you this part of, if you left your email address with you, we're going to send you a full, what is called a case report and legal analysis. We will email that to you as soon as the press conference is over, along with the press release. Now, this time I'm going to turn it over to Mr. Porter to go over this.
So this is the second special prosecutor.
Good afternoon. My name is Danny Porter. I was elected as district attorney in Gwinnett County in 1992. I left office after losing the election in 2020, and I retired in 2020. I started as a prosecutor in 1981. Over the course of those 37 years, I prosecuted police officer and police officer misconduct, beginning in 1992, where I charged an officer with murder and sought the death penalty. I've tried officers that have assaulted women on the side of the road during traffic stops. I've prosecuted officers who assaulted motorists. One of them was my last year in office, which was publicized here in Atlanta, where 2 Gwinnett County officers assaulted a driver. So that's more or less what Pete asked me to do in this case, was to review the case and actually try and determine whether either of these officers face criminal charges. I think we need to make sure that we understand that our job in this case is only to decide whether or not these officers face criminal charges. We don't decide policy violations. We don't decide any other facts or any other issues other than that. And that was the nature of our review. I did take on the case after Pete asked me to. I know that I asked him, isn't there anybody else that will take this? And apparently no one else wanted it. So I was retired and I don't have anything to lose. So I said, what the heck, I'll do it. And was immediately sorry for that. But once I got into the case, it became.
It's worth noting what this special prosecutor is saying here. Nobody wants to take these cases because they're political lightning rods. Only bad things can happen to you. That's the state of our criminal justice system, where what's an obvious legal conclusion that this use of force by the officers was lawful takes exceptional courage to argue. Folks, do you want to be a defendant in that legal framework? You better hope to God that people are willing to stand up for you, that they're not going to succumb to the political pressure. You better hope you have a robust legal defense of people who are not scared of the politics, not scared of being called a racist.
It's very evident that this case was incredibly documented on video. There were cell phone videos, there was a Wendy's security video, there was a body camera video, all of which gave a truly complete picture of the incident almost from the very beginning. But that videotape, I have sort of a rule, is that video never lies. So sometimes it doesn't always tell the truth. And truthfully, this video was the video, because it was from so many sources and so many different kinds of video camera, didn't integrate very well in a way that you could coherently watch the original videos to determine what had happened. And I recommended that we hire an expert, both in the use of force by police officers and to do the video analysis. And I recommended For Science, and they hired Mr. Alvin as their video expert. So as we look at this case, initially with the video, it looked one way, but it became very clear, and we'll show you today with excerpts from those videos, that a different incident happened that has been released both by former prosecutors and by other sources. And what Pete described is clearly shown in the video. So what we're going to try and do today is try and show you initial points, and I'll describe the videos as they come and try. Can I come around this podium? Okay, I'm gonna. So basically what we're going to talk about here is whether or not the officers had probable cause when the conflict began and their initial encounter. So the first video that we want to show you is this is Brosnan. This is Brosnan actually when he pulled up, and as police officers say, he went 1080. So this is when Brosnan pulled up into the Wendy's. The white car you see there, that's Mr. Brooks' car. Come in. Hey, come in. Hey, man, you're parked in the middle of. Right now. Hey, sir. You all right? You're sitting in the drive-thru line here. What's up? So you're parked in the drive-thru line. You're blocking traffic. You were sleeping when I walked up here. What's up, man? You used to have a long day or something? What's up? All right, yeah, you just get walking, people calling, people are walking, all right? You good? You don't need anything like that? Are you tired? All right, man. I'll move my car. Just pull somewhere and take an hour. All right. All right, you good? All right. You can see that as Brosnan goes back to the car, he turns back, and he realizes that Brooks is falling back to sleep at the wheel of the car. They're telling me I have to go back behind the podium. Come in. Come in. Let me go back to sleep. You gotta move your car. Come on back to sleep. Come on back to sleep. Okay, why don't you move your car into a parking spot, okay? Right now. All right. Don't go back to sleep. Just go over there. Okay. All right. Thank you.
See if we can watch the car jump over the curb here.
As Brooks drives away, he pulls into a parking space. And it's not revealed on the camera, but he drives up over the curb into the ground.
There he goes.
Back down into the parking. You see in the shadow of the car that Brosnan is observing his driving, and at some point he walks over to obtain the driver's license that Mr. Brooks has. He runs it for any outstanding warrants, and then at that point he begins to notice an odor of alcohol, and that Mr. Brooks's eyes are glassy, and his speech is somewhat slurred, and he suspects that Mr. Brooks is under the influence of alcohol. So he then calls in a DUI officer. Atlanta has a policy where the patrol officers call in officers that are DUI trained in each zone. This is Garrett Rolfe, who appears as the zone DUI officer. These are body cam videos.
Yeah, I was on, you know, like, you have to wake him up, kept him out, open the door, shook him, woke up super groggy, that's no previous smell, alcohol beverage coming out of the car, eyes of water, glass deep, sort of where it really was. And, time we had one drink, he said earlier, standing side, said, I think it was one drink, like, no, I don't want to go. And, kind of, where are you coming from? So I'm coming from, Jones, where I got food. So what do you got more food? So he's really not too clear, like, that I could hear it's not there, but I mean,
So this was a 911 call, right?
yeah, the drive call.
So somebody called because he was in the drive.
He passed out.
Passed out in the drive.
Yep.
That's right now.
Yeah, I had to go right away, and then we pulled out the exits, over the curb, onto the grass, like, backed it off.
Okay.
So I, you know, we just,
Sure. All right, move on. What's the name? Yeah, I didn't get it. Hey, Mr. Brooks. Mr. Brooks. Hey, I'm Officer Rolfe, the Atlanta Police Department. How you doing? I'm doing just fine. All right, so tell me, I wasn't here, so can you tell me what?
This video is supposed to be on.
got there, but I mean,
So this was a 911 call, right?
yeah, the drive call.
So somebody called because he was in the drive.
He passed out.
Passed out in the drive.
Yep.
That's right now.
Yeah, I had to go right away, and then we pulled out the exits, over the curb, onto the grass, like, backed it off. So I, you know, we just,
Sure. All right, move on. What's the name? Yeah, I didn't get it. Hey, Mr. Brooks. Mr. Brooks. Hey, I'm Officer Rolfe, the Atlanta Police Department. How you doing? I'm doing just fine. All right, so tell me, I wasn't here, so can you tell me what?
All right, after the conversation and the field sobriety test, which we didn't include in this clip, because it takes about 20 minutes to do, Rolfe reached the conclusion that he was driving under that he believed he was driving under the influence of alcohol, and he began the process of placing him under arrest, which can be seen in this video. I want to note here particularly that the police didn't come into this encounter hot. There was no hostility. They were businesslike. They were polite. Brooks didn't seem to be like a danger. He didn't seem angry. It's one of those cases where it's just sort of a regular police citizen contact that doesn't seem to be of note at all. So at this point, this is actually when Rob.
For the people I see in the comments saying, why didn't they cuff him earlier? Why do you think if they had tried to cuff him earlier, he simply wouldn't have started fighting them and fled then? Why do you magically believe that if they'd cuffed him earlier, the bad outcome would not have happened? He didn't comply with being cuffed when it happened. Why would he have complied with being cuffed earlier? In any case, the police don't just go around cuffing people every time they talk to them. That's just not how that works. And the people of Atlanta, Georgia probably wouldn't want their police doing that. They don't cuff people until they need to.
Decides to administer the breath test.
I don't want to refuse anything.
It's yes or no. It's completely up to you.
Yes, I will.
Okay, just wait here while I grab it. All right, just take a deep breath in. Mouth over mouthpiece, as hard as you can, somebody stop. Whoa, 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 stop. Very good.
That's bad.
How many?
1.5. Like I said, I went into the second cup. I wasn't even. I told her, man, let's go because I'm hungry.
What kind of drinks did you have?
I'm not sure. It's something she ordered. She said top shelf or whatever.
Top shelf what?
I'm not sure. It was, like I said, it was her birthday and it was my daughter's birthday intent to, have a good time. And I said, hey, I'm hungry. Let's go. My baby's mom, she was there. I said, hey, go ahead. Cool.
Shout out to the baby mamas.
Go up there tomorrow. Here's the money for, to enjoy herself tomorrow. You want to get a burger or something? Just let me know. I'm ready to go.
So you had about 1.5 drinks.
I really don't before.
All right, I think you've had too much to drink to be driving. So put your hands on your back for me. Put your hands on your back.
Here's the fight.
At this point, the body camera for Rolf is knocked off and it lands on the pavement, lens up. So basically the rest of the recording on Rolf's body camera only has audio. And the same thing happens to Brosnan's body camera. It gets knocked off. Luckily, it faces up, so we were able to capture the audio. So the legal principle that we're dealing with here is that when an officer with probable cause seeks to arrest an individual, that person is not free to flee or resist the arrest. Although he retains the right not to speak with the officer, it is unlawful for a suspect to flee a pursuing police officer in an attempt to escape arrest. So the two charges that the officers have probable cause to arrest at this point are DUI and escape. They could charge misdemeanor escape. They could charge resisting arrest. At this point, those are the two basic charges, but it's important to note they have probable cause to arrest him once they make the move. Here is where I'm going to go into the resistance assault and flight. In a previous statement, it was stated that Atlanta police policy requires that you notify an individual that they are under arrest prior to placing them under arrest. That's not correct. The Atlanta police policy does not require that. And as a result,
And these are the kind of lies that the public is told that outrages them, because then they say, well, see, it's required that he be told he's under arrest. And he wasn't told he was under arrest. Folks, if they're obviously arresting you, you're being informed by the conduct of being handcuffed that you're under arrest.
we found that Officer Rolf's attempt to arrest him was clearly within the law. This is a customer in the drive-through who filmed on a telephone, on a cell phone, the fighting or the fight. And you can see that from this distance, from about this point on, I don't think there's any other way to describe it, but Brooks proceeds to beat the crap out of the two officers. But again, as I said, video never lies. But until you break these circumstances down, it's really hard to tell what's going on in that video. And that's how long it takes for this to explode into violence, that Brooks fights his way out and runs down to where the red car is, and that's where Rolf fired the fatal shot. So what we did is we broke down the videos, or had the videos analyzed and broken down into still photographs. This is a frame-by-frame analysis. What they did was they stabilized each of the videos and synchronized them. Then they added in the video to the timeline, and we were able to determine second by hundredths of a second at each step of the video, depending on the frame rate of the video. So the first photograph that we show is this is the first time Rolf makes physical contact with him. You can see he doesn't jerk him around. He doesn't try and slam him to the ground. He more or less is touching his hand to maintain contact of it and starts to put the handcuffs on him. Mr. Brooks at that point lunges forward with his left hand, and you can see in the circled area that he is actually escaping the handcuff. The handcuff's not closed. He manages to pull his hands out. Brosnan's hands are on the right side of the picture, and he is trying to hold Brooks' right arm. Officer Brosnan at that point, when they go to the ground, he tries to do what's called a drive stun with his taser. A drive stun is where you use the probes on the taser, you pull the trigger, and it's what's called a pain compliance device. In other words, it inflicts pain so that the person will stop doing what they're doing. In this case, that's fighting the officer. Rolf is the one with his back turned to the camera, and Brosnan is the one on his knees there holding it. The next slide shows that Brooks sits up, despite having Rolf on his back, and grabs the taser before the drive stun can be completed. He grabs Brosnan's taser, and they struggle over the possession of the taser. At this point, Brooks lifts Rolf off his back, and throws him out into the parking lot, and gets him off of him, which allows him then to start to rise to his feet. Rolf is thrown to the ground, and he is in control of Brosnan just outside on the other side of them. He has got Brosnan down on his back, basically, and is holding him with his left hand. They're still fighting over the taser. Brosnan tries to maintain control of the taser that's still in the left hand of Mr. Brooks. I can't leave the podium, but you can see it in the yellow is the taser, and it's in Brooks's left hand. Brooks picks up Officer Rolfe a second time and throws him off and throws him forward onto the ground. So Rolfe, he concentrates on Brosnan, and he gets Brosnan's taser away from him while he leans over him and holds him to the ground. This is a wider shot of that. Rolfe is still trying to control Mr. Brooks' head and shoulders, but he has the taser. He then strikes Officer Rolfe with his right arm and hits him in the neck and hits him beside the ear. At that point, he still has the taser in his left hand, and he begins to transfer it to his right hand in this frame. Here you can see that the taser has been transferred to his right hand, and at that point, he starts to use it. It's pointed at Officer Rolfe. At the same time, he's pushing Brosnan back off his feet onto the ground. He then Rolfe at that point uses his own taser. He tries to deploy the taser against Brooks. Mr. Brooks uses the taser. He fires the taser, which you can see the flash on the taser on the left. In that case, he is firing the taser at Officer Rolfe, or at least the probe show is headed in their direction. And you can see that we can tell the taser is being discharged because of three things. There's a puff of smoke, there's a spark, there's also a flashlight on it that comes on every time you pull the trigger. We also know that it was deployed at this point because the taser has an internal device that tells us the exact time every time it's activated. So we correlate the time on the timestamp of the video to the time on the taser. We know this was Brosnan's taser, but he was firing it at Rolfe. Video tells us that. He turns and then starts to try and do a drive stun on Officer Brosnan. At this point, he's not successful. Brosnan.
I know the closed caption is saying dry stun as if it were the opposite of wet stun. What it should read is drive. You drive the tip of the taser into the target's body and press the trigger. So it's a contact, it's a pressing use of the taser as opposed to a projectile use of the taser. Drive, like driving a car.
And manages to raise his left arm and ward off the taser. But he has Brosnan, who's on his knees, and he's trying to do a drive stun on him. A second pop goes off, and that is Mr. Brooks using Brosnan's taser to fire the probes at Officer Brosnan. Brosnan has his arm up, as you can see. They're on one head, but you can see at this point, a second pop's heard, and Rolfe tries to deploy his taser against Brooks. Those probes miss and don't strike. In the meantime, Brooks is turned down over Brosnan and is still trying to hit him with the taser. At that point, Brooks fires at Officer Brosnan. Brosnan was struck in the hand by the probes from the taser. He had some effect from the taser. He's also by this time had a concussion because his head was bounced off the pavement. Rolfe is still trying to get a shot on the right-hand side of the picture with his taser, which he then deploys as the second deployment. You know, in this case, that one of the tasers, they hit Mr. Brooks. One of them was lodged on the back on his right side where you see that little puff in his shirt. The other lodged in the shirt, so therefore it didn't connect, didn't have an electronic connection. So when Rolfe pressed the trigger, he didn't get the effect. The taser did not immobilize Mr. Brooks. But Brooks at that point turns and starts to run around the cars. Brooks is hooked to him by the taser probe that's in his back, and he is running, chasing / following Brooks, attached to him by the taser lead. At this point, the officers have developed additional probable cause to arrest Mr. Brooks. The charges that we believe that would be appropriate had this.
A lot of charges here, folks. Felony. Looks like they're all felonies. 4 felonies.
Stopped at this point. At everything stopped. They could have arrested Mr. Brooks for felony obstruction of a law enforcement officer, which is, of course, when you obstruct or resist an officer with violence. Removal of a weapon from a public official, which is the taking of the taser. Aggravated assault on a police officer, which is the use of the taser, both against Rolfe for firing it and on Brosnan for actually hitting him and shocking him. And then possession of a firearm during the commission of crime, which would be possession of the taser. So in addition to the initial probable cause, the officers now have additional probable cause to arrest. This is the force. We've looked at all of the uses of force, including this combat that we've shown you, but the primary place of our investigation is the use of deadly force. And what we've done here is there's a Wendy's video camera that captures the chase from one end of the Wendy's parking lot all the way to the end where the actual shooting takes place. To give you an idea of the time frame, it takes 17 seconds to play this video, which means it took 17 seconds for that chase to occur and for the things that we saw in the video. When you watch it the first time, which I'm going to let you do now, well, when we watch it the first time, it's very hard to pick out details until you break it down frame by frame, and we've done that. We've broken it down into 3 chases. So the first one, this is the Wendy's video. The only thing that's been done to it is been stabilized. It has not been sped up or slowed down, although the GBI report did contain a slow motion version of it. The experts gave us this. They call it cleaning up, but it's only been stabilized and brightened a little bit. There's no changes. All right, the next video is the first. I asked that they break this chase, our technical folks break this chase down into 3 parts, because I think those are the most critical portions of it. You can see how fast it went and how fast decisions had to be made and choices had to be made. This is the first third of the chase. You can see them come out from behind. You can see him come out from behind Brooks's car. That's him fleeing from the fight, and he starts to run. In this picture, if you look closely, and you might not be able to in this medium, but if you look closely, the taser wire is visible in the space between. So Rolf is still trying to taser Brooks, and you can tell they're very close because they're only one part of the width of one parking space apart as they run. If you look closely, you can see that Brooks has the taser in his right hand. Okay.
And I'll point out too that during this time, multiple witnesses confirmed that they saw Rolf trying to tase Brooks, but with no effect. And the reason there was no effect is simply because both probes did not land.
All right, this is the second part of the chase that I asked that we break out to show you. This is part 1. Now it goes on. At that point where you see the flash of the taser, and when Brooks turns back over his right shoulder, and he activates the taser, that's the flash. Rolf, at this point, you can see he moved his taser to his left hand, and he is moving towards his firearm, which is on his right side. This is at least one of the times that Brooks activated the taser between here and there. Okay. So then the next portion, the next slide, are the breakdown. Here you see in the circled area, Rolf is running with his taser in his right hand, and Brooks is running with Brosnan's taser in his right hand. You can't see, but they're attached by a wire from Rolf's taser. Here you see the actual still photograph of Brooks activating the taser over his right shoulder in the direction of Rolf. You can see Rolf has either dropped or has moved the taser to his left hand and is starting to move towards his firearm. There's the clear-cut shot of the taser going off. Here, Rolf actually runs into the red car, but he moves to the red car. That is a second taser discharge right there. Remember, both of the probes are gone. He shot both of the probes. And you can see Rolf is drawing his weapon at that point. He ends up hitting the fender of the car, and he hits it right around here. So he runs into the car, but you can see his right arm is extended. The experts told us this was the first shot. That you can tell by the change in luminescence of the video that the weapon discharged right here, and that's the first shot. You can see that Brooks is partially turned towards the officer on his right side. He still has the taser on his right side, and he continues to run. From the video evidence, this is directly from the report of the experts. From the video and audio evidence, there were approximately 1.1 seconds between the time Brooks fired the taser and Officer Rolf and the time Officer Rolf returned the fire with his gun. During that second, Rolfe drew his weapon, oriented the weapon in Brooks's direction, and pressed the trigger. Georgia law says that when a suspect threatens an officer with deadly force and then turns before the officer can respond with a gunfire, the result can be a gunshot wound in the back. In this case, however, Brooks fired the taser at Officer Rolfe and continued to aim the taser at him while running away, which turned his body to the right. And at that point, when Mr. Brooks pulled the trigger after deploying the taser at Officer Rolfe, Brooks was able to twist his upper body to his right, reach back with his right arm, and deploy the taser. That meant that Brooks's buttocks were directly towards Officer Rolfe, and the autopsy showed that one of the bullets entered his buttocks.
And this was, I think this report is about, this is Georgia law, this is from the expert report.
Right. I'm sorry. This was from the expert report. And his back was partially exposed, which explains why the two wounds were on the back part of his body. In this case, Officer Rolfe's first shot was fired while Brooks was still aiming the taser at him. All three shots were fired in approximately 0.56 seconds. Now, this is Georgia law when an officer may use deadly force. And what we did here is we gave you the code section, and under each code section, we put in bullet points of what we believed were the appropriate facts as to each section of the code section. So the code section begins, peace officers may use deadly force, but it gives three instances. The first is when the officer reasonably believes that the suspect possesses a deadly weapon or any object, device, or person which would use defensively. In other words, it can be a everyday object, but it can be used to inflict serious injury or death.
By the way, folks, this is a legal justification for Rolfe to use deadly force as a police officer that's parallel to his privilege to use deadly force in self-defense. So he still has a self-defense privilege, just like any of us would have a self-defense privilege. This doesn't replace this. This is a parallel justification because he's employed as a peace officer.
That can be considered a deadly weapon. Under case law in Georgia, which is part of our review, a taser can be considered a deadly weapon for these purposes. So you see that, number one, they were both officers. So that is important. This is not something that citizens do. Excuse me. Brooks had taken Brosnan's taser and had deployed it while he was still in fight, which gave off a reasonable belief that he was armed with a deadly weapon. Brosnan described the pain and of being tased, and that Brooks had pointed and deployed the taser at Rolfe multiple times during the time he was running away. An officer can also use deadly force when he reasonably believes the suspect poses an immediate threat of physical violence to the officer or others. Well, the factors that we looked at here is that Brooks had already overpowered two officers and violently brought both of them to the ground. He had overpowered them. That's another word for it. He took a weapon from Brosnan. He struck Rolfe on the right side of the head and neck. He deployed the taser against both officers. He ignored repeated commands to drop the taser and to stop. So I think the officers would have had a reasonable belief that he could commit an immediate threat of physical violence. And then the third section is when there's probable cause to believe that the suspect has committed a crime. We've already got, or that the crime has to involve the infliction or threatened infliction of serious bodily harm. And you can see that we've placed the charges here again, which Brooks could have faced had it stopped at any point short of this. So it's our finding, or it's my finding, in this case, that Officer Rolfe acted in accordance with Georgia law. He acted in accordance with Atlanta police policy on the use of deadly force. He acted in accordance with the controlling case of Tennessee versus Garner and Graham versus Connor. Based on the facts and circumstances confronting Officer Rolfe and Officer Brosnan in this case, my conclusion is the use of deadly force is objectively reasonable and that they did not act with criminal intent.
Okay, folks, I think I'm actually going to wrap it up there. They don't add much more substantive to the rest of this press conference. We're an hour into it and 2 hours into this show. But I'm sure if you Google it, you can watch the remaining, 20 or 30 minutes of this, if you like. But for me, I'm going to wrap this up so I can get home, grab something to eat, and get to jiu-jitsu this evening. For all of you. Before I do, though, I will take a look. Let me take a look at the, let's see, member topics here. Let's see. First from the Law of Self-Defense members, and then I'll turn back to the Super Chat. Could I speak? Member Rick asks, could I speak to the weaponization of the Department of Justice? Folks, if we want the government to function differently than it is, and I would agree that it certainly appears to be weaponized politically, you need to elect different people. So we elect bad actors, we get bad government. We ought not be surprised by that. Rick also mentions, and I saw this in the YouTube comments as well, you can be detained with cuffs and not arrested. Yeah, but it doesn't matter for our purposes. If you're having handcuffs placed on you, you know you're being restrained by law enforcement officers. It's not a mystery. It doesn't have to be stated. Garen, we would tell the suspect, presumably as an officer, Garen, a law self-defense member, you're not under arrest. We're handcuffing you for your safety and ours during our investigation of this matter. Sure. But that doesn't become unlawful conduct if you don't say those words. All right, let me take a look at the super chats. Refresh that. And it doesn't appear there are any new ones, but YouTube super chat function is not great. But it does look like I got them all. All right, folks. So with that, I will wrap up today's show. Thank you very much for joining me. Please tell your friends and family. Subscribe, thumbs up, leave a comment, all that stuff. And I'll plan on doing a show tomorrow unless I inform everybody otherwise. Until then, I'll just remind all of you that if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill. Then you also owe it to yourself and your family to make sure you know the law so you're hard to convict. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.